Hello, a couple of interesting cases in Bulletin 38. The first is Young and Martin, which is an interesting case where parties purchased a property as joint tenants. One of them put in the cash, the other one supported it by a mortgage. When the person who'd supported it by the mortgage died, the surviving joint tenant alleged that there was an agreement whereby the estate of the deceased joint tenant would be responsible for discharging the mortgage, and the issue then was if there was such an agreement, and the court said that there may have been some arrangement but it wasn't clear, so it failed on that basis. And the other comment that I think was relevant was the judge saying that equitable principles would not require the estate to discharge the obligation of the testate or to pay out the mortgage in relation to a property that was not part of the estate of the deceased joint tenant. I think it's instructive in that if there is such an arrangement, then it's very important that it be documented. That might have helped the plaintiff in this case. The other one is a family provision case of Demanti and Demanti, and that again is not an unusual family provision claim, except that it was telling on the applicant because the court found that he had not established or addressed the issue of need, which is obviously a serious oversight, and evidence that his accountant gave on his behalf in relation to certain loans that he may or may not be able to have effected was, I think, in the words of the judge, were completely inadequate. Again, a bit of trial preparation and review of the evidence required was being highlighted. In the briefly section, there's a couple of cases mentioned. The one I think worth commenting upon there is one where there was a document which the court was not satisfied was intended to be the last will or a will of the person, and that the issue of testamentary capacity had not been addressed in relation to the proving of an informal will, two key elements to get an informal document accepted for probate. Thank you.